Welcome once again to Lehto's Law. Here's Steve Lehto.
Nathan tipped me off to a story from Reuters. And we talked before about qualified immunity and about how everyone's hopeful that the Supreme Court's going to wake up one morning and go, qualified immunity's got to go away. And that's the concept that police officers and certain other entities in our government can't be sued for what they do as long as they're acting in their official capacity. And there's all kinds of weird rules and exceptions to this. But the strange thing is that the U.S. Supreme Court just rejected a case over qualified immunity. And this is one of those cases where you go, wait, why would they reject it on that case? Andrew Chung wrote it, and Jim also sent it to me, by the way. The U.S. Supreme Court Monday sidestepped a chance to review the scope of a legal defense called qualified immunity that increasingly has been used to shield police accused of excessive force, turning away an appeal by a Cleveland man who sued after being roughed up by police while trying to enter his own home. The man wanted to get into his own house, and the police roughed him up. And so he thought that he should be able to go after them for that. The Supreme Court declined to hear the case by the man who said he was slammed to the ground outside the house where he lived with his mother. He was 20 at the time. Qualified immunity protects police officers and other types of government officials from civil litigation in certain circumstances, allowing lawsuits only when an individual's clearly established statutory or constitutional rights have been violated. What clearly established statutory or constitutional right do you have to get into your own home? That apparently baffles the Supreme Court. The U.S. House of Representatives last Wednesday passed policing reform legislation that, among other provisions, would eliminate the qualified immunity defense for law enforcement. The legislation, however, faces an uphill battle in the Senate, where it is not expected to pass. This particular case of the man trying to get into his own home was featured in a Reuters investigation into qualified immunity published in December. The man sued the two police officers, accusing them of excessive force in violation of the U.S. Constitution's Fourth Amendment prohibition on unreasonable searches and seizures. The officers said they only used the force necessary to subdue him. And again, they're subduing him as he's trying to get into his own house. Now, you might say, but Steve, search and seizure? Most people in here, search and seizure, concentrate on the search part. Seizure is the other part. So search is, I'm going to dig through your stuff. Seizure is when I take your stuff or I hold you. That's a seizure, okay? So it is improper for me to unlawfully seize you the same way it's unlawful to search you, if in fact it is so. The Cincinnati, Ohio-based 6th U.S. Circuit Court of Appeals in 2020 granted the officers qualified immunity, ruling that no clearly established precedent showed that their actions were unlawful. Again, what's the clearly established precedent that says that you have the right to get in your own house? They have the right to try to stop you from doing that, apparently. In May of 2020, a Reuters investigation revealed how qualified immunity under the careful stewardship of the Supreme Court has made it easier for police to kill and injure civilians with impunity by shielding them from lawsuits, even when courts determined that police actually violated a person's constitutional rights. Law enforcement professionals and some U.S. conservatives have argued that qualified immunity is essential for police to make quick decisions in dangerous situations without fear of lawsuits. But again, you'll notice that's different, because a quick decision is one thing, but when you're beating up a guy who's trying to get into his own house, seems like mistakes were made, weren't they? In recent months, the Supreme Court has signaled a potential softening of its approach to qualified immunity. In two cases, the justices allowed inmates to sue prison guards who had been granted immunity by lower courts from accusations that they violated the Constitution's Eighth Amendment prohibition on cruel and unusual punishment. So that's the one I talked about a couple weeks ago. But the guy who was in prison, and they stuck him in the most inhumane conditions that you wouldn't put an animal into. And that case, at one point in time, looked like it was going to go nowhere, because what rights did they violate? And the Supreme Court said, well, no, cruel and unusual punishment. You're not allowed to do that. Our Constitution prohibits that. And so just as clearly as cruel and unusual punishment is in the Constitution, so is the unlawful search and seizure. And it is one of those things where, again, I'm a lawyer. I went to law school, practicing law for 30 years now. I taught law school for 10 years. And so I do tend to think like an attorney. But I think I'm capable of shifting gears dramatically here and stepping outside of the lawyer arena and thinking about this like a regular non-lawyer person. And I think this is the kind of thing where there's a huge disconnect between the legal community and everyone else. And by legal community, I mean judges, I mean lawyers, police to some extent, because all of that group looks at this and goes, well, what clearly established right is there? The man was trying to get into his own house. He was trying to get into his own house, and they beat him up. Now, I know some people are going to go, but Steve, let's talk about the facts of the case. No, let's not. There's a reason why not. For the purposes of an appeal, certain facts are presumed to be true. You may have heard the phrase arguendo, assuming something arguendo, for the sake of argument. So for the sake of argument, the Supreme Court will assume those facts are true. The man was trying to get into his own home and the police beat him up. Okay? So don't argue the facts, because the facts actually are not what we're arguing about here. We're arguing about the legal issue. If what he's saying is true, can he proceed? The Supreme Court's saying no. The Supreme Court's saying even if every word that guy says is true and the police are completely full of it, he still can't proceed. That's the problem. Because many of the cases that we hear about on appeal never went to trial. They were dismissed prior to trial. And motions like that, summary judgment motions or summary disposition, we call them in Michigan, where a party will go in front of the judge and go, there's nothing to try here due to the legal issues. And a court can actually say, you know, you're right, and throw the case out. So that gets appealed. On appeal, it's often the case that we presume the facts to be true, just for the purposes of the appeal. So when this case comes before the U.S. Supreme Court and they file the application, they're asking the court to hear this case, it'll say, these are the facts of the case. And the defendants will even say, doesn't matter. We agree those facts could be true. Doesn't matter. We still deserve to win because there's no clearly established precedent. And we've talked about this circular reasoning before, where it would take one court to say that you cannot beat up a man trying to get into his own home. Otherwise, you violate his rights. And once they say that, then a person comes along later can cite that as precedent. But based on this logic, the only way you can get that ruling is if you have a prior ruling. And so you have, I hate to even call it circular because you can't get the circle started. It never starts. You have to have the precedent to set the precedent. And you're never going to get that. So, assuming the facts are true, the man in Cleveland was beaten up by cops trying to get into his own home. And the Supreme Court saying the cops had no way of knowing that was a problem. They had no way of knowing that. How would they know that? There was no clearly established precedent. And since this case got shot down, this case can't become precedent. And people who study economics in the broadest sense of just the science of rational thought will tell you that when people discover that there's no rules enforcing something, the enforcement just goes out the window and things get worse. So what happens when police find out that there's no clearly established precedent saying you can't get beat up trying to get in your own house? It's not good. It's not good. So it's a strange case. It's unfortunate because people were hopeful. People were hopeful. After the prison case with the guy who actually succeeded, he'll get to get in front of a jury with his story. We were hoping that maybe the Supreme Court's going to start granting more of these cases. No, they just denied this one. And is there actually any pattern to what they're doing here? Who knows? Because they don't ever explain that. They never say, by the way, here's why we did this, as opposed to that. Nah, they'll write a long opinion that'll justify their ruling, but it does appear they're basically saying, oh yeah, yes, no, yes, no. And the Supreme Court, on one level, is supposed to give guidance to the courts beneath it. So when different rulings come up on the same issue, to them, they're the ones who say, oh, here's how we'd rule on this, and they'll straighten it out. But when they start doing this ad hoc, crazy quilt thing of yes here but no here, all bets are off. All bets are off. So what is the clearly established precedent that shows that the laws protect a man trying to get into his own home? And again, only people who are tunnel visioned in the legal system can even wrap their head around that. Because everyone else goes, that's just crazy. That's just crazy. And I've said this before. I've seen opinions where judges write something where you go, that's almost like bizarre to think that that's a person writing that opinion. The lug nut case in Michigan, where I've done several videos about this. The Court of Appeals in Michigan said that a shop can start a tire rotation on someone's car, take the tires off, put the new tires on, and forget to put the lug nuts on or forget to tighten the lug nuts. And they can charge you for that. And if something gets hurt by that, you can't sue them and win because they started the job. And the law says they have to perform the job. And perform, start, same thing. And as many people noted, if any Supreme Court justice in Michigan went in and got their tires rotated, and as they're driving out, their wheels fell off, you think they'd actually go, well, you know something? That's the law. I got no problems here. No. So when the Court of Appeals ruling was appealed to the Michigan Supreme Court, they denied hearing it and actually said, there's no controversy. There's nothing to hear. Really? Do you own a car? Have you ever paid to have work done in the car? Did you expect the work to be completed? So I do think there is a problem in the legal system. I'm not sure what the solution is, but I do think that a lot of people who spend their lives or decades in the legal system, judges in particular, lose track of the fact of what it's like to be a regular person with real world problems. And do you really think a Supreme Court justice is ever worried about being beaten up by cops trying to get into his own home? Of course not. Can't even relate to that. Can't relate to it. So to him or her, it's completely theoretical. That's the problem. So U.S. Supreme Court rejects case over qualified immunity for police. Reuters published it. Andrew Chung wrote it. Nathan and Jim sent me. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Will shampoo that promises to give you extra body and volume make you gain weight? If so, I'll immediately switch to dishwashing detergent that promises to dissolve fat that is otherwise difficult to remove.